Good evening, ladies and gentlemen, and dear audience. On behalf of Conflict and Resilience Research Institute Canada, I welcome all of you to the fifth episode of War in Ukraine. Today, we have a humble project. We are going to discuss about the role of United Nations in conflict resolution. We have invited two distinguished speakers to share their thoughts with us this evening. Before we proceed into our main event, let me do the treaty recognition. Conflict and Resilience Research Institute Canada is located on original lands of Anishinaabe, Cree, Oji-Cree, Dakota, Dene peoples, and on the homeland of Métis Nation. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. Dear audience, as I promised, before I introduce our distinguished speakers, let me give you a brief situation update. As most of you are aware, that on the humanitarian front, we have seen a number of developments over the past week. We have seen how the Red Cross convoy was turned back from Mariupol, and also we have seen a number of activities in the north and northwest. In the military front, we have seen a new strategy as shared by Russia, and they are leaving some of the parts of northern Kyiv and focusing more on the eastern front. In terms of international actors, we have seen NATO continue to support and sending more troops to the NATO countries and supporting with military hardware so that Ukraine can keep fighting. And we have also seen the President Volodymyr Zelensky speaking throughout the globe in all the parliaments and rallying support to stop the war. And very recently, he also spoke in the International Emmy Awards, which was fascinating. Ladies and gentlemen, today, as I've said, we are very much honored to have Honorable Senator Mary-Lou McPherson, who was born and raised in Manitoba, and it's a distinct privilege to once again introduce her. She has come to our webinar a couple of times in the past when we was talking about Rohingya refugee crisis. Senator McPherson in 1985 became the youngest lawyer to be named as the member of the Order of Canada in recognition of her co-leadership of the ad hoc committee of Canadian Women on Constitution. McPherson's work has focused on the promotion of human rights through systemic reform in law, medicine, education, and governance in Canada and internationally. She has co-founded several widely recognized not-for-profit systemic change organizations, including the Women's Legal Education and Action Fund, briefly known as LEAF, the Metropolitan Action Committee on Violence Against Women and Children, commonly known as METRAG, and the International Women's Rights Project, which is based on two of our intergenerational models, evidence-based advocacy and lived rights. She is also affiliated with the Women, Peace and Security Network. She was also the Dean of the University of Winnipeg Global College in Manitoba between 2008 and 12. And in October 16, Senator Mary-Lou McPherson was named to the Senate by Prime Minister Justin Trudeau to sit as an independent. And this is why we are so proud to have her with us today. And before I let her share the screen, let me also share with you that on March 22nd, Honorable Senator has spoken in the Honorable Senate about Canada's role and the entanglement that we see in the United Nations Security Council about the veto. And in the same day, there was an opinion piece written by Lloyd Exworthy and Alan Rock, two of our distinguished Canadian leaders in international affairs, titled "The United Nations Can Use Its Blue Helmets to Save Lives in Ukraine." Dear audience, you can always Google it and read the whole opinion piece, wonderfully written, well laid out suggestions, and based on which we have developed our today's webinar. So without further ado, let me first welcome Honorable Senator Mary-Lou McPherson for her opening remarks. Senator, floor is yours.
Thank you very much, Professor Ahmed, and I want to thank you also for your land acknowledgement, to which I would like to add that the Parliament of Canada is situated on the unceded unsurrendered territory of the Algonquin and Anishinaabe First Nations. It is an honor to share in this panel with Professor Jennifer Trahan. I want to note that the column referenced already by the Honorable Lloyd Axworthy and the Honorable Alan Rock specifically mentioned the research that you have done and the writing you have done, Professor Trahan. So I'm very honored to be on the panel with you this evening. I have been asked to speak more specifically about Security Council Resolution 1325/1325, and in speaking about that resolution adopted in 2000 by the Security Council, establishing the beginning of a suite of now 10 resolutions on the theme of women, peace, and security, that really should be seen as complemented by the resolutions much more recent on youth, peace, and security. So although I will typically reference women, peace, and security, I hope you will also hear as a subtext youth, peace, and security. One of the hallmarks of the Security Council Resolution 1325 is that it was really the first resolution of the Security Council that was largely drafted by civil society, by women leaders in civil society, who worked very closely with a number of countries that were on the Security Council at that time. And I'll mention specifically Namibia and also Bangladesh, and Ambassador Chowdhury, who was the representative of Bangladesh on the Security Council at the time, because these country representatives were prepared to listen, they were prepared to make adjustments, and they were prepared to work through the intricacies of the Security Council system in order to bring this resolution forward. What we have had since then have been a series of other resolutions that have been sponsored by a number of different countries. But in particular, we saw in 2008, 2009, sponsored by two different women secretaries of state for the United States, resolutions that looked specifically at gender-based violence, in particular rape as a weapon of war, and addressed the reality of this primarily for women, although we know that gender-based violence is also used against males and other genders. I want to pause here and just pull up on my phone a text that I received early this morning. It went out actually last evening, and it is from a Ukrainian activist. It is not verified. I'm just reading verbatim from the text that I received. Russian soldiers loot, rape, and killed 10-year-old girls with vaginal and rectal tears, women with swastika-shaped burns. Russian men did this. Russian mothers raised them. A nation of immoral criminals. A number of these reports have come out from many different spokespeople, mostly spokeswomen from Ukraine. I want to particularly note statements that have come from members of parliament, some of whom I've had the pleasure of working with over the last number of years in organizations such as the Interparliamentary Union and the OSCE Parliamentary Assembly. These MPs include Lesia Vasilenko, Alona Shkrum, Maria Mezenteva, and Sofia Fedina. And what we know about some of these members of parliament is they refuse to leave, and many of them are carrying an AK-47 on their back at the same time as they are trying to continue their role and their responsibilities as parliamentarians. I think it's fair to say that when Security Council Resolution 1325 was developed back in 1999, 2000, and adopted in 2000, today was never envisioned. This degree of an illegal invasion by one of the permanent 5 members of the Security Council, the unprecedented since World War II degree of the war, the nature of the war. We're now starting to get reports about the use of mines, being left in bodies of people that have been civilians that have been murdered by Russians. And this brings into play a whole range of treaties, the Mines Treaty. It also raises the specter of a nuclear war. And this, of course, is probably the primary reason why we see that plea after plea from the Ukrainian president and many others speaking for Ukraine and from Ukraine for a no-fly zone is not likely to be respected and implemented. It is the fear of the escalation to a nuclear war, a war that nobody will win, everybody will lose, and it may be the end of all human civilization. And so what are we left with? We have lots in the way of a legal infrastructure. I'm going to leave to Professor Trahan to speak more specifically about that. But what we know is that every UN special rapporteur or special representative of the Secretary General, such as Pramila Patten, have called for the protection of humanitarian corridors. Clearly, this falls within every aspect of the suite of Security Council Resolution 1325 and pretty much anything else we can think of by way of international law. But how do we do it? The suggestion has been made for the potential use of blue helmets or peacekeeping forces. I spent part of the weekend talking to a number of experts that work within the UN system, and quite consistently what I heard back from them is that we have, shall we say, a less than stellar reputation of blue helmets in numerous countries where there has been serious abuse and misuse of their authority. And so the level of trust is not at the high degree that we would hope for. I don't have an answer here tonight, but I do think it is well worth continuing these kinds of discussions using the framework of international law and remembering that international law is the law that is at a higher level than any of the UN charter resolutions or other forms of jurisprudence that are generated by the Charter of the UN. And so we have some overarching laws that need to continue to be applied here, and where there is a consistency between international freestanding law and the jurisprudence generated out of the Charter of the UN, that's where I think we need to focus. Thank you. I'm going to turn it over to Professor Trahan now.
Thank you so much, Senator, for your, I would say, very uplifting and enlightening speech. And very importantly, she raised a point, what are we left with? I think it's a profound question. With this one, I would like to now invite Professor Dr. Jennifer Trahan. And before I let her speak, let me have the privilege to read her bio, spectacular bio. She's a clinical professor of global affairs at New York University, teaching international law, human rights in theory and practice, international justice, transitional justice, and the field of intensive on war crime prosecution in the former Yugoslavia to The Hague, Bosnia and Serbia, as well as a field intensive to Rwanda. She served as a counsel and of counsel to the International Justice Program of Human Rights Watch, served as Iraq prosecutions consultant to the International Center of Transitional Justice, and worked on cases before the Special Court for Sierra Leone and the International Criminal Tribunal for Rwanda. She is also an author of Genocide, War Crimes, and Crimes Against Humanity, a digest of the case law of the International Criminal Tribunal for Rwanda, which was published in 2010, and Genocide, War Crimes, and Crimes Against Humanity, a topical digest for the case law of the International Criminal Tribunal for former Yugoslavia, published in 2006. She contributed various book chapters and scores of law reviews, and she is also a member of the New York City Bar Association Task Force on National Security and Rule of Law, and a member of the International Law Association's Committee on the Use of Force. She also taught at Columbia University, Fordham Law School, Brooklyn Law School, and she is now the convener of the Global Institute for the Prevention of Aggression. It's such an honor to have you with us. And once again, let me also share with you, dear audience, a couple of key points from her latest book, which was just published in 2020, titled Existing Legal Limits to Security Council Veto Power in the Face of Atrocity Crimes, and which was published by Cambridge University Press. She mentioned in that particular book, in the opening couple of chapters, that three independent bases that she outlined for the existence of legal limits to the veto by the UN Security Council permanent members while atrocity crimes are occurring. First, the Council must not act inconsistently with jus cogens, which is called peremptory norms of international law. Second, the veto power created by the UN Charter must be exercised in accordance with the UN's purposes and principles. And thirdly, there are also positive obligations imposed by the Geneva and Genocide Conventions, to which all permanent members are parties. And I am going to let the professor speak herself now and unpack the couple of things that Honorable Senator also mentioned, and enlighten us how to intervene in the conflict. Professor, without further ado, the floor is yours.
Great. Thank you so much for that kind introduction. It's my great privilege to be here, and I'm also very honored to appear on the panel with the Senator. So I will discuss the situation in Ukraine and what is possible in terms of rule of law, and then also what is not possible because of veto paralysis, because of Russia being a permanent member, and whether anything can be done in this respect. So everyone listening has probably seen absolutely horrific images of what appear to be appalling war crimes. You know, when one apartment building is hit, you think it might be a mistake, but when you have just widespread attacks against civilian objects, it looks like a clear pattern of war crimes. We're now seeing, you know, horrific new images of mass graves. As the Senator mentioned, sexual and gender-based violence. We're incredulous, that a theater which said children on both sides, clearly visible from the air, is bombed. So, and we're also horrified by the invasion itself, an invasion by a permanent member of the UN Security Council, which is the body charged with maintaining international peace and security under the UN Charter. So it is a dismaying time in terms of the rule of law, but we do have some progress in terms of the rule of law. I say this, you know, obviously recognizing it is not stopping the conflict, but we have had a clear denunciation of Russia's aggression in the General Assembly. It passed 141 votes in favor, only 5 against. We've had an unprecedented 41 referrals of the situation to the International Criminal Court. We used to have referrals by 1 state, at most 5 states. So we've never had this many. So a huge endorsement for the International Criminal Court. Now we have an outpouring of funding and commitments for personnel. Even in the United States, which only so recently had put sanctions on the International Criminal Court prosecutor and one of her high-level staff, is making positive sounds about the International Criminal Court. Civil society is mobilizing, trying to document the crimes and preserve evidence. We have like-minded countries gathering together, both at the UN and, of course, in imposing sanctions. The Human Rights Council have created a commission of inquiry to investigate human rights violations and crimes, and the commissioners have now been named. The US is proposing kicking Russia out of the Human Rights Council. And amazingly, despite being under attack, Ukraine has gone to the International Court of Justice and obtained a ruling that the argument that there was genocide occurring in Donetsk and Luhansk that could have potentially maybe justified this is absolutely specious and cannot be a possible reason for the invasion. It was simply a pretext, basically. And we've seen national countries in about 10 countries start national investigations into war crimes, crimes of aggression, or both. And we have calls for an ad hoc crime of aggression tribunal, which I believe the president of Ukraine has now as well called for. So these are all positive developments. I say this with, you know, the sense, of course, it is not stopping the conflict, which ultimately I fervently hope will be solved by some kind of peace agreement. Where the UN system is absolutely failing is, of course, at the UN Security Council level, and this is because of Russia's veto. So what this means is we have paralysis of this body. So we won't have condemnation of these crimes by the Security Council. In fact, that is faced an actual veto. We won't have Security Council sanctions. We won't have the Security Council creating these humanitarian corridors. We won't have any kind of enforcement measures through the Security Council. We will not have a referral of the situation, which could have involved the crime of aggression, to the International Criminal Court. We won't have a freestanding tribunal created like the Yugoslav and Rwanda tribunals were created through the UN Security Council. So what to do when we have this paralysis? Well, the General Assembly has certain powers it could try to utilize. Obviously, it did condemn Russian aggression. It can also recommend all the measures the Security Council could take, but the General Assembly's primary power is to recommend. It cannot impose. It can recommend things, and then states can implement them if they wish to do so, unfortunately. So it is a very problematic paralysis. Let me switch a little to the crime of aggression. So I've already mentioned the International Criminal Court is going to go ahead and investigate war crimes. There seems a lot to be done. The International Criminal Court, I hate to say, reality check usually doesn't prosecute that many people in each situation country. So I think we're in a situation where the public, probably the people of Ukraine, have, you know, huge demands for accountability. They really want large-scale accountability. So states are responding by upping the International Criminal Court's budget, but it has not kind of been designed. It usually does a few high-level cases. So this does leave, I think, a lot of room for national prosecutions, in Ukrainian courts, universal jurisdiction in other courts. So there is a role, because it looks like there is just a lot of accountability that will need to be done when all of this is at some point, hopefully, finally passed. And just to say, Ukraine is not a party to the International Criminal Court, but it has done something very similar. It's executed what is called an Article 12.3 declaration accepting the court's jurisdiction. But this is only creating jurisdiction over genocide, war crimes, crimes against humanity in Ukraine. It is not creating jurisdiction over the crime of aggression. Unfortunately, this has a different jurisdictional regime, and it is, honestly, it is the United States that carved out the nationals of non-state parties from the regime, and this has now exempted Russia. So this was in 2010 at the International Criminal Court Review Conference, and then actually the UK and France further narrowed jurisdiction in 2017. So this is, I think, really problematic and needs to be fixed. This could be fixed. I think the current situation, if there is desire for prosecution of the crime of aggression in the current situation, which there seems to be, I think we have a very good model, which would be a tribunal created by the UN and Ukraine, and this would be a hybrid tribunal. It could sit in The Hague, it could sit in Ukraine, it could sit where they agreed to have the tribunal sit, and it could have jurisdiction over the crime of aggression. We have it defined already in the International Criminal Court statute. This is this would be created by agreement of the UN and Ukraine, and the General Assembly could recommend this structure. This is the model, I believe, that should be followed, needs to be followed. It is a multilateral model, unlike the UK's calls for domestic countries pooling jurisdictions. So at the domestic level, we have certain immunities problems, like heads of state could be immune, senior government officials could be immune. Well, if you're looking at who started the crime of aggression, you want to make sure you're in a jurisdiction that isn't going to have these immunities issues. So I think the UK model that is being set forth of pooling domestic jurisdictions could carry this immunities problems with it. And it has certain optics, selectivity concerns that I think are ameliorated if you go through the United Nations. What do I mean selectivity? It's a little bit rich for the UK, which joined the US in going into Iraq in 2003, to now use the crime of aggression against Russia. This is why we have it in the International Criminal Court, so it should apply to all countries. And this is how we need to, at some point, get there and have more countries ratify the crime of aggression amendment, but we also need to revisit the jurisdictional regime. The states parties to the International Criminal Court need to increase the crime's jurisdictional reach. These events just really show the centrality of the crime of aggression. If we don't have aggression, we don't reach all these war crimes. And this is, the famous quote from Nuremberg in the judgment. It said the crime of aggression is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. So again, if you don't have the aggression, we don't even get to all of the carnage that we are seeing. So I do think this is a moment for us to reflect deeply. Are states really committed to the crime of aggression? Then they should all ratify this amendment, increase the court's jurisdiction, and then we don't have to deal with ad hoc approaches. If we do have an ad hoc approach, I think it's important for legitimacy that we do it through the United Nations. And just to say, we clearly have a very clear crime of aggression. We've had an invasion. In fact, Belarus is also implicated because it's allowed its territory to be used for the invasion. And these are very clearly covered in the International Criminal Court's definition. And if you have an invasion under the definition, senior political and military leaders who initiate the invasion are responsible for the crime of aggression. We're just grappling with how can this be prosecuted? Where can this be prosecuted? I wanted to say a little bit about also, there's so much to discuss about Ukraine, and I'm happy to do more in the questions and answers, but just to say a little bit more about the veto power. So we've had Russia veto its own condemnation for aggression, Russia violating many provisions of the UN Charter and failing to allow the Security Council to fulfill its mandate as the primary body charged with maintaining international peace and security. So it's using its veto in a way that contravenes all these other provisions of the UN Charter. Well, it was never stated in the UN Charter that the veto is above the remainder of the Charter, or the veto is above all of international law. And this is another area the international community really needs to work on. So my book argues that we have to question the legitimacy of the veto cast in the face of ongoing genocide, war crimes, crimes against humanity. So what do I mean? I mean, the Security Council, you would never expect them to draft a resolution endorsing genocide. And in fact, we have Judge Lauterpacht in the Bosnia arms embargo case. He actually said one reading of the Security Council's arms embargo in Bosnia was, if it's facilitating the better armed Serb side to commit genocide at Srebrenica, it would be void. So a Security Council resolution endorsing genocide, of course, would be void. But if you have genocide occurring and you have a proposal to try to stop the crimes, and that's vetoed, that's endorsing the continuation of the genocide. And we have the same thing for war crimes and crimes against humanity, with absolutely abusive vetoes in Syria that blocked condemnation of crimes. They blocked a referral to the International Criminal Court. They blocked all these measures trying to prevent chemical weapons attacks. And then the vetoes blocked even humanitarian assistance. And I kind of scratch your head and say, this cannot be how the Charter is designed to be read, that a veto can block humanitarian assistance. That is in fact contravening all these other parts of the UN Charter. We have the same thing with the veto threats. So China uses veto threats, not the actual veto. So it is really the veto threats of China that weakened sanctions during the Darfur genocide, when at a time the Sudanese military was working with the Janjaweed militia to commit the genocide in Darfur. We have China weakening the sanctions regime, weakening the peacekeeping mandate, and delaying the deployment of peacekeepers. It's similarly why we will not have a tribunal to deal with the genocide against the Rohingya through the Security Council, it would be vetoed. Referral of the crimes internal to Myanmar to the International Criminal Court would be vetoed. Any measures to address the genocide, the slow-moving genocide against the Uyghurs, a mass sterilization campaign, and when you do a mass sterilization, forced sterilization campaign, eventually you eliminate the Uyghur people. But we will not be seeing Security Council play any role in this, of course, because of China's veto. My book, and I'll end with these thoughts, argues we need to look at the veto as mentioned in my lovely introduction, in light of our obligations to respect our highest level norms of international law. They're called peremptory norms of international law protected at the level of jus cogens, which includes the prohibition of genocide, war crimes, and crimes against humanity. My book, I didn't write about aggression, but now I wish I had, and I need to write another book, because the prohibition of use of force contrary to the UN Charter is also protected at this highest level. And that's what most recently has been violated. My book also looks at the veto in context of the remainder of the UN Charter, and argues that, again, the veto is not meant to be above the other legal obligations, such as adhering to the purposes and principles of the Charter, including respecting international law. And the veto needs to be in line with treaty obligations, such as the obligation to prevent genocide, the obligation to ensure respect for the Geneva Conventions. So states need to be tackling this question. I'm really pleased, since this is a Canadian audience, to say that Irwin Cotler, Alan Rock, Lloyd Axworthy have been, and Errol Mendes have been prominent supporters of asking these questions. And what I'm urging in my book and in my additional work that they have graciously joined me on is to ask states to simply go on record and say the veto needs to be used in line with the UN Charter and with international law. And I'm very pleased that Canadian ambassador to the UN, Bob Ray, has made just such a statement twice, in an R2P debate and then in the Security Council. I'm really heartened by this. Many states need to take this position. States in the General Assembly could pass a resolution discussing the limits to which the veto is subject under the Charter, or they could take this question to the International Court of Justice for an advisory opinion and ask, is it permissible to veto measures stopping the prevention of genocide, war crimes, crimes against humanity? They could also challenge a particular veto. They could also bring a suit under the Genocide Convention or under a torture convention. So I think I have 4 ways that states could tee this issue up for litigation. So I'll stop here. Thank you.
Thank you, Professor. I would say a very well-rounded discussion, and some of the legal matters that our audience have come to know very clearly from your discussion. Ladies and gentlemen, the audience will move to the moderated Q&A session now. And the way we would like to conduct is we are going to invite our advisors, Darcia and Gary Senft, to kindly join the discussion. And I shall also pose some of the questions to our distinguished speakers today based on the theme, and also both the Honorable Senator and Professor Jennifer Trahan, they have discussed this evening. So first, let me welcome our advisor, Darcia Senft, to pose a question. Darcia.
Thank you. First of all, let me say thank you for that very comprehensive explanation, Jennifer and Senator Mary Lou. Both of you together have given us an amazing summary of these very complex issues, and you've done it in 10 or 12 minutes apiece, so I applaud you for that. I have a question. I think I have a legal background. Of course, I'm a lawyer. I'm not here in my capacity as a lawyer for my employer, but I am a lawyer. But I think anyone watching this who isn't a lawyer, I think the initial frustration and the immediate question was, can't something be done? And you very nicely outlined, you've ended off with 4 ways that the member states can go about getting things done. As the legal mind, I'm looking at it and I see years of court and struggle and fighting, and I hear the advisory opinion route, and I'm wondering, isn't there an ability somehow through the international law, the norms, to get some kind of injunctive relief, or to get almost like a stated case where you can put a basic issue before a court and say, let's take away all of the extraneous issues. Please rule right now on this basic question about whether the veto is illegal, not an advisory opinion. I mean, everyone looking at it, of course, it makes no sense. It makes no sense that the veto could be used in this context. But if we need a judge to say it, is there not a way to expedite that, to have a judge make a ruling or to get some kind of an injunctive relief for, as I say, a stated case? That's my first question.
I guess that's a question to me. Thank you for that one. So you can ask for expedited relief from the International Court of Justice, and they did rule quite promptly when Ukraine sued Russia and arguing that the court needs to clarify that there's no genocide in Donetsk and Luhansk. And the International Court of Justice did rule quite expeditiously. So an advisory opinion, as you know, is just advisory. So you could have an egregious veto, and that could be sent by way of an advisory opinion. The way I have thought of having an actual case would be under the Genocide Convention, if we had a clear veto in the face of genocide, or under the Torture Convention. And here I should say, I know that Canada has been working with the Netherlands to tee up a torture convention suit against Syria. So, you know, states are really effectively making use of the International Court of Justice, as in Gambia suing Myanmar under the Genocide Convention. So all of a sudden, we're looking at a lot more state responsibility in parallel with international criminal responsibility, in parallel with criminal responsibility. So these questions, I think, could be teed up. I can't tee them up. A state could tee them up. So Canada could press this agenda at the UN. So, and as I say, a clear veto in the face of genocide, but it's difficult as well, I should say. China is one of the countries that has the reservation against being sued under the Genocide Convention. And recently we had 5 of the International Court of Justice judges say that kind of reservation needs to be revisited. But right now there is that reservation. So if you were to bring a suit under the Genocide Convention against, for instance, China, you have to first challenge the legality of the reservation, and then you bring your lawsuit. So, and you could expedite things, but you know, these are difficult processes, but it is such a huge question. And I should say for about 20 years, we've approached this. Permanent members, please don't use your veto in the face of atrocity crimes. And after 20 years, we have this commitment by the UK and France. So that obviously is not doing it. So we do need to explore these legal routes and press these kind of cases. Because I will just say, for any in the audience who don't know, that the charter is veto proof in terms of amendments. So you have to get all permanent members agreeing to an amendment of the charter. So the veto isn't going anywhere. So I'm thinking we need to approach it from a legality question because the voluntary initiative seems not to work for 3 of the permanent members. And therefore it needs to be pursued.
Thank you. Thank you very much, Professor. Thank you, Darcia, for the question. And I will revisit the question because I have a similar question. And Honorable Senator, please jump in. Thank you.
Thank you very much. I want to build on what Professor Trahan has been saying, but I also want to invite all of us to think outside of the UN box. What we've seen, for example, in Gambia versus Myanmar, where yes, we've had a good degree of collaboration, particularly between the Kingdom of the Netherlands and Canada in trying to focus on gender-based sexualized violence in that genocide. But we're talking years later, folks. We're nowhere near any resolution. So this will not come as a surprise to anybody who's been engaged in any legal system, be it international or be it domestic. This is the slow road, Darcia. There's no equivalent to a fast domestic injunction here. Just, there isn't. So let me suggest that really what we're seeing in the way of potential progress are the decisions of certain countries making a decision to just step forward together. We're seeing also statements from the European Union, and I think we have to not let NATO off the hook here. Yes, it's true that NATO has expressed, understandably, very great concern about allowing any escalation in fear of nuclear war. It's legitimate. It's a genuine concern. But we have seen numerous examples of where NATO countries have worked together and have taken more concerted action than we've seen so far. We've seen some strong individual NATO member contributions, and I'll include Canada in that list. Could be stronger. We do need more. But I think we need to also be able to envision and advocate for a stronger collective response from NATO itself.
Maybe I can add just one thought to that a wonderful intervention of the senator. So we did actually get a good ruling in the Gambia-Myanmar case, a provisional measures order basically to stop the genocide. So in terms of teeing up the veto, all we need is a courageous country on the Security Council to put that order to stop committing genocide in a resolution. If one of the P5 vetoes it, that is your case of a violation of the Genocide Convention through the veto power. So there is a litigation strategy that we could pursue here. The law is frustrating in terms of when you want to stop the crimes immediately, and it's really hard. It's not the most immediate, but we have to, use the tools we have at our disposal. And we're not always. So there are, I think, additional ways to press this. Just to say for anyone watching, the International Criminal Court has on its docket crimes that occurred in both Myanmar and Bangladesh. Bangladesh is a state party to the International Criminal Court. So a crime such as forced deportation occurred both in the territory of Myanmar and in Bangladesh, and the court is pursuing that. But the International Criminal Court is unable to pursue the genocide which occurred within Myanmar. So that's the impasse that we're hitting, which could be cured if we had a functional Security Council. They could refer the events in Myanmar, but we don't have a functional Security Council, and therefore that accountability is blocked.
I would just add to that and say that, yes, we did get the provisional ruling. It would be very nice if it wasn't kept a secret, as it has been. There's a lot of accountability and transparency that's lacking in the ICJ process. But over and above that, it saddens me greatly to say we got the provisional decision. There's still a genocide going on.
Absolutely. And this is what is the problem that we face in the international arena. Thank you so much, Honorable Senator, for weighing in here. Let me welcome Gary Sent here. Gary, if you have a question, please go ahead, sir.
Yeah, again, starting with a thank you to both of our speakers who are, truly amazing. And I think out of this session, we should keep track of the things that we can do and, try to be catalysts for that. I guess we're talking about in this situation invoking potentially war crimes, crimes against humanity, genocide, and crime of aggression. Now, I've probably missed a bunch like landmines and all other kinds of breaches of the Geneva Convention, for example. There is no mechanism in the United Nations for actually ejecting a country, a member, never mind a veto right for simply saying, sorry, you're out of town, because is just too outrageous.
Professor?
Well, I think maybe one of the first questions that has to be asked in response to that question is, hypothetically, if that kind of exclusion were to happen, what would that accomplish?
That would accomplish the coalition of the remaining willing, which hopefully would be all other countries, who might then take some more serious action, because it seems that people are frustrated by the fact that they think they have operational rules. So I don't know, Senator McFedrin, but that it's a scary thing that you're having, they're on the Human Rights Commission, like, come on.
Yeah.
Yeah.
Right.
So I have been asked, could the fact that the UN Charter actually says the Soviet Union holds
Yes.
the Security Council seat, so
Yes.
could anything be made of this?
Yes.
And I have to say, I'm a little bit skeptical, because for 20, 30 years, we've said Russia holds it. So kind of the doctrine of estoppel or waiver, I don't know if we can go back words on that. That's an argument like we should have thought of in 1990, but we didn't. And then the other problem is that actually it has the wrong name for China as well in the charter. So the moment we kind of open this can of worms, why is Russia holding the Security Council seat? It's opening another can of worms, and I doubt the international community wants to go there. So, that has been one question raised. I think we could tease some of these legal questions. Russia's veto of its own condemnation of aggression at a time when it's violating all these provisions of the UN Charter. There are legal questions that could be asked. They could be sent to the International Court of Justice for a ruling, an expedited ruling. As I mentioned, aggressive use of force, so invading another country, is also prohibited at this highest level, a level higher than the level of the UN Charter. I do think there are legal questions that we can put to the International Court of Justice, which I had never thought was really an activist court, and it hasn't had that reputation, but it's made some good rulings in the Gambia-Myanmar case. In the Bosnia versus Serbia case, it has had a huge exposition of what it means to prevent genocide. And it actually says every country has an obligation to prevent genocide if they're a party to the Genocide Convention. And it went into all of these obligations. And it's not just to stop genocide in your country, but to stop genocide in other countries. And it's actually a really powerful ruling. We need to get some of this good law applied.
Thank you. I also find it interesting that we're worried about estoppel arguments, for example. Meanwhile, we're being subjected to this Russian aggression that is so off the charts. So one wonders if the United Nations members didn't simply vote such, sorry, it was the Soviet Union, you're out, whether or not it would, what are they going to do? Take it to court? That's going to take 10 years? At least they'd be gone. I'm sort of being facetious, but as a lawyer, it is difficult, just to do these things. So I'd really encourage the actions that you're thinking about and things that could be taken on an expedited basis. But I wouldn't mind turning it back to Kauser, because I should mention that Kauser is actually a United Nations Blue Helmet veteran, and probably can comment a bit from personal experience in the military as well as academic background.
Thank you, Gary. So we are just up at the end of our session. So I'll leave with one question to both our distinguished speakers today. Just echoing from Gary's comments here. So my question is, can we do something as an international community to at least do something to support besieged people of Mariupol in terms of UN Charter Chapter 7, which we call peace enforcement, and we take it from General Assembly because UN Security Council, as all of you have agreed in principle, that is not going to function because of the veto imbroglio. So can we at least do that and for a very limited period of time send relief to Mariupol? 100,000 people are besieged and they're going to die if we do not act in promptness. And I'm suggesting, can we take it to General Assembly like 1957 Suez Crisis? We can build a coalition, as Honorable Senator said, think innovatively what you can do beyond Security Council. What are your expert opinions on that? Thank you.
Let me jump in and say, I still think it all comes down to the humanitarian corridors and anything that we can do to A, establish them, B, protect them, and C, actually get the flow of support is the practical necessity of what we're discussing tonight. And it's good to have rulings, but it will come down to unified, coordinated action. I would imagine that every one of us on this call tonight is contributing in some way personally, probably to someone we know personally who is working on various ways of getting in supplies. I certainly know that's very true of Gary and Darcy on the call. However, what I want to invite everyone to do as my closing remark is to say that let's also think ahead. We're mired right now in the unspeakable tragedy of this war, and it gets worse every hour. However, at some point, we're going to move into some kind of resolution. And my closing comment is that we need to have done the legwork as advocates with our own governments to have them ready to be able to move forward with an inclusive and effective peace negotiation. And that means the peace table must include women, and not the outer tables, not the outer rooms, but the actual inside peace table. And countries like Canada need to be prepared to say there is no legitimate peace process until there are women at the table. And that's the essence of Security Council Resolution 1325 and the whole suite of resolutions around that. But it's more than that. That's the essence of humanity.
Thank you, Honorable Senator. Professor.
Yeah, I would simply completely endorse the senator's remarks. I think those were perfect remarks. We absolutely do need humanitarian corridors. The issue of protecting them is where it gets, I think, more dicey, because then we get in, do you mean protection through air power? And then we get into why we don't have a no-fly zone for fear of triggering World War III. So this is, incredible difficulty. Ultimately, I think this situation has to be resolved at the peace negotiating table. Law isn't going to resolve this. Law is going to come afterwards and try to address some of the war crimes, but law is not going to solve this. So we need at the peace table. Let me just put on one additional topic we haven't talked about, and it is reparations. So the people of Ukraine no doubt want accountability, but if they've had their houses, their lives destroyed, they've lost a lot of money. Their lives have been, they've lost loved ones and or, huge monetary losses. And I think this needs to be part of the table, negotiating table. We have difficulty creating a claims commission through the Security Council because it would be vetoed. So I think this is part of the peace negotiations, and we could get rather creative. Remember, there is frozen Russian assets in US and other banks. Now, some of this can be used for reparations, and you also might be creative about a flow of, Russia's sale of future oil revenues. And maybe part of that should go into funding a reparations program. So, it should not be, Russia should own the responsibility for funding the rebuilding of Ukraine. And that is one of the topics that should be on the peace table. And those are a couple of ideas how this could be started. So I'll end.
Thank you so much. Thank you so much, Professor Jennifer Trahan, for bringing the issues of war reparations that we sometimes speak And we need to also think innovatively, as Senator Marilu McFadden rightly mentioned about the international negotiation and peace negotiation and how Canada can take a lead on this matter. Ladies and gentlemen, dear audience, we are at the absolutely last part of our session. We formally conclude, but before we conclude, we always touch base with the people of Ukraine, those who are suffering the horrendous crime of aggression orchestrated by Russian Federation so far. And I would like to play a small clip of resilience of Ukrainian people over the past 5 weeks that kind of resonate with me and many of our people in Canada. We support Ukrainian struggle against this oppression, and it's a very innovative clip because it was recorded from one of the basements in Lviv, and it is an opera that went viral in some of the social media websites. So just have a brief listen, and we shall conclude thereafter.
The haunting sound of a violin fills a bomb shelter in Ukraine. She's a soloist with the Kharkiv City Opera. Her city is under siege, the theater's dark. So every night, Vera Litovchenko puts on an evening gown and plays underground as the streets above are shelled by Russian missiles. The violin has become an instrument of resistance in Ukraine, boosting the spirits of a besieged people who love classical music. This extraordinary video features 94 violinists from Ukraine and around the world playing a Ukrainian folk song in perfect harmony. It was put together by British violinist Karenza Peacock.
It was a tremendous show of support, and I think it was really the most powerful prayer to try and spread harmony across boundaries.
In the city of Odessa, the citizens are doing what they can to protect their beloved.
That is all we had to say in closing our session. We would like to express our gratitude to Professor Jennifer Trahan, who joined us from New York this evening, and our own Senator Marilu McFadden from Ottawa. Thank you for your insightful talks, and we have received a number of questions and comments from the audience, but I'm not taking those just to be cautious about time. But we would like to also express our heartfelt gratitude because you have explained what are the problems in international law, and especially in the UN Security Council. We don't want to end the episode with a pessimistic tone, rather just to highlight that, yes, there are many things could be done. You have heard Senator Marilu McFadden's recommendation of international peace negotiation. You have heard Professor Jennifer Trahan's number of recommendations of taking this case to ICJ. Maybe it would take some time in order to take these things into effect, but we look forward for the quick resolution of the conflict so that people get relief and also take the aggressor in the court. And with these few words, let me conclude today's session. Thank you very much for being with us for over an hour now, and we look forward to have another session in the near future. Please tune in Conflict and Resilience Research Institute Canada, www.cric.org. And till then, we see each other. Ukraine, we stand beside you. We support you. Have a good rest of the night. Good night.
Thank you.